All right, I'm calling this meeting of the Township of Ocean Planning Board to order. Can I have a roll call, please?
Councilwoman Kaplan? Mayor Napatani?
Here.
Mr. Berkowitz?
Here.
Mr. Goslin?
Here.
Mr. Manel? Ms. Delaney? Here. Mr. Bogdanovich? Mr. Maney? Vice Chairman Palutis?
Here.
And Chairman DeFilio?
Here. Salute to the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. The notice requirements of the Open Public Meeting Law for this meeting have been satisfied. A copy of the notice having been sent to the Asbury Park Press and the Coaster and filed in the office of the Township Clerk. There is emergency exit through the courtroom doors and 2 exits at the rear of the room. There is no smoking. That includes vapes and e-cigarettes. Board policy is no new cases will be started after 10 p.m. and no new testimony taken after 10:30 p.m. In addition, the applicant will be limited to 45 minutes of testimony. All meetings will be video and audio taped and shown on the Township of Ocean's Community Cable Channel, Channel 77 on Verizon Fios, and Channel 77 on Cablevision. All cell phones must be turned off, or if you need to make a call, please make your call outside the meeting room. All right, first order of business this evening is we have resolution memorialization, B.C. Brielle, LLC, 3501 Brielle Ave, Block 183, Lot 7, in the I-1 zone for an extension of time. Do I have a motion to accept this resolution?
Who's eligible for that?
It was pretty much nobody, just Chairman DeFilio, it was like 2 years ago.
No. When we voted on the extension in September,
That's who can vote on it.
that's who can vote on it.
You got an extension given in September?
Yes.
Yes, this is the resolution for the extension.
Memorialization.
Yeah.
I'm sorry, Nicole.
No, you're fine. It's one of those days we have. Maybe we do this one last, and we'll come back to it, together.
Okay.
Okay, we will return to the resolution memorialization. I believe Nicole, because our next one is the fee schedule for ordinance 2530.
So basically what we're doing is it was charged a fee, a flat rate fee for variance applications. And the township has been paying a lot of money out of their pockets for that. It's not enough. So we're going to escrows. And this way the reviews, the inspections, and there will be paid for by the applicants. Whatever's remaining in the escrow account will be returned to them at the end of the project. But it stops the township from paying a lot of money.
And that's standard throughout most townships
Yes,
and municipalities. I've actually been surprised Ocean Township hasn't done it. So.
What's happened here is that an applicant will submit an application, gets reviewed by the professionals, the township gets billed, then they amend it, and the township gets billed again, and sometimes this has happened 4 or 5 times on the same application. So it really winds up being onerous for the township.
The governing body is 100% in agreement with that, because currently the way it works is if there's more money spent on our professionals that we have to pay for, everybody in this room winds up paying for other people's variances. So this protects the municipality. We're all for the fees. We've spoken about it, so it makes a lot of sense.
Do any of the board members have questions on this?
You would need a motion, you need a second, and you should do a roll call.
Okay. Colleen, can you handle a roll call?
We do need a motion in a second.
Yeah, I'm just waiting for Colleen to get that. Okay. I'll make this easy. I'll make a motion to accept this. Do I have a second?
A second.
Oh. I think I got Mr. Goslin here.
Okay.
All right. Roll call, please.
Second, Mr. Goslin?
Yes.
Motion second on ordinance.
Okay. Okay. Mayor Napatani?
Yes.
Mr. Berkowitz?
Yes.
Mr. Goslin?
Yes.
Ms. Valente?
Yes.
Vice Chairman Palutis?
Yes.
And Chairman DeGolia?
Yes. All right, our next order of business is we have an administrative request for two properties located on Chatham Ave, Block 25.13, Lot 11.01, and Block 25.13, Lot 11.02.
So, Mr. Chairman, in the, before the meeting tonight, our professionals have taken a look at this application and what's being proposed administratively, and I believe, and I'll transfer over to Jim and, the two of you and Bennett, and it's my understanding you believe there actually are variances that are being triggered by what's being proposed.
I believe so, yes.
Okay, so if there are variances that are being triggered, then this is not eligible for administrative approval, and they would have to notice for that variance relief. So it's really not appropriate to be before the board tonight.
Great, so can you please communicate to the applicant that they need to notice and bring it back to the board?
Yep.
Anyone have any questions on that?
Okay.
Oh,
Are you counsel? Are you one of the attorneys?
I'm the assistant attorney for the applicant.
Okay, come on up. Counsel.
okay.
On behalf of the applicant.
Good evening. Go ahead. Take a seat. So, you just heard from our professionals that they believe that this cannot be heard as an administrative request, as there's variances needed, so, someone want to explain this?
We didn't think that there were any variances that were triggered, but I guess
There's a variance at least for the setback of the window wells, but there's also a deviation from the residential site improvement standards for the width of the driveway. It was reduced from 20 feet to 18 feet. And it's to have two parking spaces there, which they will need for this residence. Under the residential site improvement standards, it'll have to be 20 feet wide.
Am I allowed to speak? or-
Yeah.
So,
Just identify yourself.
my name is Raymond Thacker. I'm the owner of 210 Chatham, 206 Chatham Road.
And I'm not going to swear him in because you're not hearing this tonight, so.
Correct.
Okay. I mean, we did get a variance, December 2023, actually, Nelson, was part of that, variance that we received. And, everything stays within the setbacks, everything, nothing changed. The only thing that changed was the bedrooms in the basement, because we presented a preliminary plan at the time when we got the variance, and when we started showing it to prospective buyers, they wanted a bedroom in the basement and then an extra bathroom, so we put that into the plans.
Did it change the number of bedrooms from what to what?
From total bedrooms in the house?
Yes.
Right, so we were 5 upstairs and 1 downstairs in the basement on one property, and now it's 5 and 2.
Okay, that could also be a residential site improvement standards deviation, because it increases the parking requirements.
So we were at,
In fact, it definitely is, because they won't have enough parking on the site, even as it's approved now. So that increases the magnitude of that deviation.
Listen,
Hold on.
Here's what we're going to do. This isn't going to be resolved tonight, obviously. So you're going to have to go back, if you disagree with our engineer, with our planner, you can have that conversation offline. And if you can come to an agreement, great, then we can put you back on for administrative approval at the next meeting. Otherwise, if he says there's a variance and you want to vary from what you were originally approved for, you're going to have to come back to the board with a variance application to get to do what you want to do.
I hear you. I was told by the zoning officer that no variance was needed and everything was perfect.
Well, sometimes the zoning officer misses something and it's got to go through planning review, which it obviously didn't do because there was an anticipation it was going to be an administrative.
Okay, so you want us to be in touch with you, Mr. Higgins?
Yeah, I think through calling.
Okay, so it's just a misunderstanding from what we were told?
It might be, and I would also like to talk to the zoning officer, see what her thinking is, but she is not fully aware of the state regulations of the residential site improvement standards.
We didn't think that it applied because it goes over already 5 bedrooms, so we...
No, the DCA has said that every bedroom that's added increases the parking requirement by 0.5 spaces. It goes up to 5 on their table.
Right, so we're already over 5.
So, gentlemen,
5.5.
as interesting as this is, and I'm looking forward to hearing it at our next meeting, this wasn't noticed, so we can't hear it, so, yeah, thank you.
Thank you.
All right, our next order of business is our area need of redevelopment study. Is the representative from CME here yet?
Yeah, just showed up a minute ago.
Fantastic. Have a seat, introduce yourself, and, let's get started.
Sorry, I'd have been here 15 minutes ago, but I thought this meeting started at 7. So I was getting here 15 minutes early rather than 15 minutes late. Put the right folder out here. There we go. All right. Hello,
Right.
thank you. Is this? Yeah.
It is on.
Well, I'm Chris Dockney from CME Associates, a professional planner with the firm. I'm here to present, understand we have another planner here. This was about a month ago. Ron Reinerson had presented the beginning of the study. We've gone back and made some revisions, a little further investigation.
And, Chris, just so you know, let me just swear you in, so anything you're gonna say this evening will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, it is.
And I'll just announce to the board, this was renoticed, and it's a new study with a new date on it, so I'm not considering it a continuation of the last hearing. We're considering this a brand-new presentation that's sort of just been completely done anew. Okay?
To a large degree, yes, I have no objection to what Mr. Larson said. Anyway, so I'm here to present to you, this is an area in need of redevelopment study, the preliminary investigation for property at block 1.22, lots 33 and 34. That's two adjacent lots, more commonly known as 1211 and 1213 West Park Avenue. I intend to probably go through this in about 10 to 15 minutes and just see if you have any questions after that, rather than kind of reading through all 80 to 100 pages of a document we have here.
Is the board okay with that? Are we good? Are we all familiar with this? So you can
Okay.
song 8 minutes.
For 8 minutes. I do tend to ramble a little bit, so it might get closer to 9 or 10, but I'll try and be brief. I think we have some other matters here this evening. But before I go into the specifics of this site, I just want to make sure we're all on the same page here in terms of what this is and what the redevelopment process is. I like to look at redevelopment as essentially a 10-step process. And what we are on right now is step number 2 of that 10-step process. So this is the beginning stages of redevelopment. I want to make sure it's clear. There's no site plan or no proposed development at this stage. There is nothing for you to vote on in terms of an actual development application. And this is purely the second step of a 10-step process, the first of which is the governing body passes a resolution that says we would like the planning board to investigate some property to see if it meets the criteria to be designated in need of redevelopment. That happened back in August, where the governing body adopted resolution R25-161, requesting that this board conduct an investigation into these properties, and stating specifically that they want this to be a non-condemnation area in need of redevelopment. That's pretty important. Prior to 12 years ago, when the state changed the laws, any redevelopment designation meant that eminent domain and condemnation was potentially on the table. That's off the table here. If this goes through more steps in this process, the township would not be able to claim this property through eminent domain. Second step is the planning board investigation, which is where we are tonight. As you have a professional planner essentially prepare a report on your behalf and come present to you to show the findings of whether or not we feel that this property can meet any one of the criteria necessary to be designated in need of redevelopment. The following steps are the governing body follows up on the recommendations from you. If they designate it in need of redevelopment, then somebody prepares a redevelopment plan. Then the town is able to potentially negotiate with redevelopers, designate a developer, prepare a redevelopment plan, which can be done either by this body or by the governing body as a new ordinance. Then you can negotiate redevelopers' agreements with the potential redeveloper, followed up by that developer submitting a site plan back to this board. And then ultimately, if that site plan gets approved, then they can seek construction permits. So those are essentially the 10 steps, and we're on step number 2. So this is early in the process. Okay, now on to what this property actually is. As I said, this is block 1.22, lots 33 and 34. 1211 and 1213 Park Avenue. This is two adjacent properties that are developed nearly identical to one another. They are, if you've been by the site on West Park Avenue, it's two buildings that look like kind of ranch houses, but they're a little bit bigger than that. They're pretty deep. There's a sign out front for Honora Senior Living. They've both been used historically, at least for the past approximately 10 to 15 years, as senior residential healthcare facilities, which is similar to an assisted living facility, not quite a nursing home, but a little bit more care given to the residents there than there would be in, say, an independent living 55-plus community. Both properties are developed. The two of them together are a little over 3 acres. One is about 1.5 acres, one is 1.62 acres. They're both developed with commercial structures that have been operating, as I said, as the senior living facilities. Don't think I need to go through land use and zoning, but the statutory criteria, the important thing here, as I said, what the laws require is before any property can be designated in need of redevelopment, we're at the second stage, which is a review at this board to determine whether they meet any one of the criteria. And I have to stress it's only required for this finding that they meet just one of the criteria. It doesn't have to be 5 of them, any one of them, and the town can designate in need of redevelopment. In need of redevelopment. I'm going to quickly go over what those criteria are. Criteria A is essentially substandard buildings. There's something less than optimal about the buildings, that they are dilapidated or obsolete. B is vacant commercial space. And that's important to note because a few years ago the state changed the law from vacant for a period of 10 years to just substantially vacant for a period of at least 2 consecutive years. C is unimproved vacant.
We only need to do the ones where A, B, D, H, where...
The ones that don't apply, I won't go over them. So we have A, B, D is obsolete improvements, and then H is the smart growth area, which the smart growth area is areas that the state has designated as where they encourage development and redevelopment, where there's existing infrastructure, and that's where the state essentially wants to see growth. The state development redevelopment plan breaks the state down into essentially 5 different categories of land use. Category 1 and 2 being the smart growth areas, or essentially the growth and development zones, and then 3 through 5 are the areas where the state wants to see conservation and preservation. So I'll get to the properties themselves. As I said, they are each developed with a single-story commercial senior living facility. Each of these has 15, we'll call them bedroom units. They're essentially the resident units of a single bedroom that range in size, although I didn't measure them each individually, anywhere from about 80 to about 110 square feet, give or take, and they each had a half bath. So they had a toilet and a sink, but no shower or bathtub in each of these units. The property at 1213 West Park was actually technically not in necessarily terrible condition, and it was occupied. Of the 15 residential units, there's 4 of the 15 units occupied, the rest remain vacant. Being operated, as I said, by Honora Health as a senior residential health care facility. Now, let's see, I'll get straight to it. The other parcel at 1211, exact same configuration, or nearly the exact same configuration, 15 residential units, same thing, bedrooms ranging from about 80 to about 110 square feet, half bath. The only major difference between the two, 1213 has 4 of the 15 units occupied, 1211 has 0 units occupied. It's been essentially completely vacant for about 3 years now, is what the records we have showed. Except for there is a commercial kitchen in the vacant building that is operated by the same facility owner, because the 4 units where there are still residents at 1213, they have no commercial kitchen in that facility, so they can't cook for the residents. So they do all the cooking in the vacant building, then they walk the food across the parking lot into the other facility to feed the residents. But otherwise, they both have dining facilities, they both have the bedrooms, same exact configuration, same basements, although 1211, the one that is vacant, had some issues in terms of there were some open electrical wires. The basement showed some signs of flooding, although at least the day I was there a few weeks ago, I will say it did rain pretty heavily the day before, but there was still quite a bit of flooding in the basement. Quite a few other issues going on there. And we do have to note, between both of these properties, one of the things we look at when we're doing these studies is we ask for records of emergency services calls. There's a rather surprising number of times, as much as these properties look like nothing is there, dozens and dozens of emergency services calls over the last 5 years to both of these properties, most of which were for very minor issues. Some of it was apparently there was a utility pole that had fallen down a couple of years ago in front of the property, but not exactly on the property. Mental health calls, you have senior population there. Emergency services for ambulances where people are in need of medical care. But in particular, at the facility at 1213, there have been just earlier this year, 4 open fire code violations. They have since been abated, but there were numerous fire code violations, including several systems being out of date and systems needing to be tested. I'll get straight to it now. For the property at 1213, we think this meets redevelopment criteria A, D, and H. This is going to apply to both of these buildings, but we'll start with just 1213. And A is the generality of buildings are substandard, unsafe, unsanitary, dilapidated, or obsolescent. And the primary focus here, we feel these are obsolescent, both of them, because they are senior residential healthcare facilities, and how they were initially designed and how they're currently being operated, and that's what the license for this facility is for. But market trends in the last decade have really been moving away from that, and people seem to want to live in an assisted living facility rather than, I'm sorry, not assisted living rather than these senior residential healthcare facilities. And that's largely because of the lack of a full bathroom, as well as a few other things. But no one seems to want to live in these anymore, which, despite the one building being in very good condition, actually, they only have 4 units occupied out of the 15. And so think, well, they could just maybe convert to an assisted living facility if that's where the market is going, that's where the money is, that's where the financing is. Except for, by state law, assisted living facilities, which is where people are going, requires that every bedroom be at least 150 square feet, which in both of these facilities, the bedrooms are much less than that. As well as, more importantly, it requires that every unit have a full bathroom and at least a partial kitchen in each unit. And since they only have half baths and they're undersized, it would be extremely onerous for the owners of the property to try and upgrade the facility without essentially a complete gut rehab of both buildings. And then they'll also lose a lot of units in expanding the bedrooms, expanding the bathrooms. They would probably go down to, I don't know, 8 to 10 units in each building instead of 15. So we feel that these buildings are obsolete, and since they can't be used or properly converted, that's leading to these vacancies here, where between the two of them, there's 30 units and only 4 are occupied. We also feel 1213 meets criteria D, essentially for the same reason. Criteria D is very similar to criteria A, but it uses a few different words, including faulty arrangement or design, as well as obsolete layout. This is the exact same thing, where this obsolete layout, and I don't really like the term faulty, because I don't want to say it's somebody's fault, or there was improper design at the time, but it's really the obsolescence here, and the arrangement of these units is leading to their vacancy, and that we see that as an issue that affects the overall welfare of the community by having these facilities not being properly utilized. And it also meets criteria H.
So I'm just going to pause you. Criteria H is going to be the same for both?
Yes.
So why don't we do the other criteria for the second line? You can come back to do H for both.
Sure. The only difference between it's A, D, and H for both, and it's also criteria B for the facility at 1211, because that one is completely vacant with the exception of the use of the commercial kitchen. And I will say what the law says there for criteria B, I'll read it right here, is the discontinuance of the use of the building or buildings previously used for commercial, the abandonment of such buildings or significant vacancies of such building or buildings for at least 2 consecutive years. So that building has, with the exception of the commercial kitchen, which is only being used because I don't have a commercial kitchen next door, that building is entirely vacant, and it's starting to show, and that's why the one building that is still being occupied there's still some maintenance and upkeep there, where this building is starting to deteriorate. There's quite a few things wrong with the building, and I think that's due to the vacancy. And the vacancy of over 2 years, our record has indicated it's been vacant since 2022. So it's a substantial vacancy. All 15 units are unoccupied, and it's a commercial kitchen that gets used only for cooking for 4 people in the other building. So it's not a commercial kitchen that's run, they're not running a Chick-fil-A out of the building. It's just to feed the 4 residents.
Gotcha. So I'm going to stop you before we go on. Does anyone on the board have questions about these criteria so far that we've discussed? All right. Can you cover H for us?
Okay, and then H is the designated smart growth areas. And as I said, those are areas where the state plan and redevelopment plan, as well as the New Jersey smart growth map through the Office of Planning Advocacy, has designated areas where they feel that growth and development should be encouraged by the state. So those are generally areas with highway access or rail or bus access, existing sewer infrastructure, and other utilities necessary to support development. So the state supports development and redevelopment in these areas, and both of these properties in their entirety are located within a designated smart growth area. So they are otherwise, they're suitable for designation under criteria H as well. As I've said, the law requires that at least one criteria be met, and for the one property at 1213, we feel it meets 3, A, D, and H, and the other property, we feel it meets at least 4, A, B, D, and H. So that being said, the crux of all this is it does appear that these properties both meet at least one criteria necessary for designation under the redevelopment and housing law. And our recommendation is that you do find that they do meet the criteria necessary, and you make a recommendation back to the governing body indicating as such.
Questions? Anything from our professionals? Jim? Well, just Jim.
I haven't been involved at all in
Okay.
this stuff.
All right, so
Don't know where Ben went. I didn't tell him he had to leave. Most places are allowed to have more than one CME employee in the same room.
you know, again, this is a new hearing, so I will limit my comments to this. This makes more sense. I think I understand the concerns about the property. My one concern is always there are residents there now. Are they safe? Does the town need to take any outside of this?
Short answer, yes. The building where there are 4 residents appeared to be completely safe. There had been the 4 fire code violations. I didn't find any evidence on my visit that these were imminent hazards, and the 4 violations had been abated. They were, again, I found that the number of calls was a little alarming. Usually when I do these studies, I put in these requests for records, and virtually nothing comes back. And it's almost a formality that we just say we've requested it from the town. I was a little surprised to see multiple pages of just the list of the number of times that 911 has been called to these facilities. But I think to some degree, when you have an elderly population, medical service calls becomes a semi-regular thing.
Okay. All right.
Mr. Chairman, you do need to open it to the public.
All right, so we will take a moment now and open this up to any members of the public if they have a question on the redevelopment report that has just been presented to us by CME. Seeing none, can I have a motion to close the public hearing?
Motion.
Second. All right, all in favor? Aye. All right, so, can I,
Mr. Chairman, if I may, if the board is inclined to recommend that this be considered a designated area of needed redevelopment without the power of eminent domain, I did produce a resolution in advance, so if that's the board's pleasure, you can do both in one vote.
I think that's well, do I have a motion from the board to accept this report as presented?
Motion.
Moved by Lanier. Do I have a second?
And that includes the resolution.
Oh, well, yeah, and so we're doing this to include, accept the report and the resolution recommending that the governing body adopt it.
Without eminent domain.
Without eminent domain.
Did you read the report or the
whole report?
No, the resolution.
I did submit it.
Yeah.
So the board should have it.
All right, I think we're good then. So roll call vote, please. Mr. Goslin.
All right. Councilwoman Kaplan?
Yes.
Mayor Napolitani?
Yes.
Mr. Berkowitz?
Yes.
Mr. Goslin?
Yes.
Ms. Valente?
Yes.
Vice Chairman Holders?
Yes.
And Chairman DeFilia?
Yes. All right, we have one last order of business that should be very quick.
Do not forget that you still have to vote on BC Burrell.
Oh, I did forget that. So we have 2 more items, but first off, let's move right along to our stormwater management plan.
So, Mr. Chairman, if I may, this is a document the board previously reviewed it. The board previously was favorable towards it. It's now coming back as a potential amendment or to be adopted as an element to the master plan. So this is a public hearing tonight. The public was noticed, so you will go to the public on it also. But it's the exact same document the board previously reviewed and found favorably towards.
And also, just so we're clear, this document is from the State Department of Environmental Protection that is instructing us to adopt it, so we don't exactly have
Correct. The things that you have to do is obviously, I believe it is tailored towards Ocean Township.
Yeah. Okay. So, any questions from the board on this matter? All right. So I'm going to open it up for a public hearing. Does anyone have any questions, comments, or concerns on the proposed stormwater management plan to be considered as an amendment to the Township's master plan? Seeing none, can I have a motion to close the public hearing?
Motion.
Do I have a second?
Motion.
No, Julia got it this time. All in favor? Aye. All right, I'm going to go ahead and make a motion to accept this stormwater management plan as an amendment to the township's master plan. Do I have a second?
And, Mr. Chairman, if I may, I also adopted a resolution in anticipation of this, so if you want to amend that motion to include the adoption of the resolution.
I think that's a great idea, so I will make a motion to accept the proposed stormwater management plan as an amendment to the township's master plan, as well as to accept the resolution prepared by Mr. Lexstein to that effect. Do I have a second?
Second.
Seconded by Mr. Palutis. Roll call vote, please.
Councilwoman Caplan?
Yes.
Mayor Napolitani?
Yes.
Mr. Berkowitz?
Yes.
Mr. Gossler?
Yes.
Ms. Valente?
Yes.
Vice Chairman Palutis?
Yes.
And Chairman DePena?
Yes. And I have a motion to close this meeting.
Oh,
Yeah. All right. Back to Brielle. To bring us back, we had Memorial Resolution BC Brielle LLC, 3501 Brielle Avenue, Block 183, Lot 7, in the I-1 zone for extension of time that was approved at our September meeting. This is the Memorial Resolution, and we need a motion.
What we need to see is who is
Yeah.
which is,
I have a list. So there's, Mr. Berkowitz, Mr. Gossler, Ms. Valente, Vice Chairman Palutis, and Chairman DePena?
Okay. So, do I have a motion from one of those folks? Motion. Do I have a second? Second. All right, roll call, please.
All right. Mr. Berkowitz?
Yes.
Mr. Gossler?
Yes.
Ms. Valente?
Yes.
Vice Chairman Palutis?
Yes.
And Chairman DePena?
Yes. Now do I have a motion to close the meeting?
Motion to close the meeting.
Do I have a second?
Second.
All in favor?
Aye.
Aye. All right, thank you.
and everyone here, just so you know, this was the planning board, the zoning board.